Okay.
Let's get the glasses on the bar. Yeah, that's brilliant. Nevertheless, what we're going to do today is, what are we doing? We're covering the Caterpillar case, right? And I'm so excited. Sorry, I feel like spring break sounds here. I'm pretty hyped. Caterpillar case, and then I thought we would do something, like actually be a real attorney for a minute. So I brought a complaint drafting exercise. I believe you know enough now to draft a very basic complaint. So we're going to do that. If anybody just hold over your hand, but if any of you are still interviewing, I should have done it earlier. We just didn't get through the material fast enough. But I try to do it where you're in your interview, you can say, oh yeah, I had a chance to draft a complaint. You kind of drop that civil procedure, and it just shows me how it emphasizes to me or helps me realize how excited I am to practice the law. Blah blah blah. Because usually you don't do that to your upper class. So anybody still has interviews left, drop that in there. They're always impressed. And that's it. So we're going to Caterpillar case, our complaint drafting exercise. I'll have some complaints I'm going to pull up on the computer to show you that I think are juicy and entertaining Kardashian kind of drama.
I need more of that Kardashian drama.
And that's it. So just to show of hands, who is leaving the state of Kentucky for spring break? Okay, I need more hands. Who's going somewhere warm? Oh God, what are y'all doing? Okay.
I'm cool.
Oh, forget it. But I told you I was about to $29 each way. I've been saying it all semester in Allegiant, which is not safe, but I just don't understand. Like when I was a student, we road trip. We road trip to Daytona. What's the other place? Workplace? Right. Like just like rent a car and put your money together and just like.
What money? We don't have no money together.
I got office hours.
Like that's that. Okay, so real talk. It's not too late to save today. Okay, so they still have those $29 fares. At least think about a road trip somewhere warm. Like I've driven all the way to Florida from Kentucky. Like
who's doing it?
Like when you get there, like Miami, like it's cool, it's warm, you got the beach. I just don't understand why you're studying.
Because we're lost.
It's just 1 week is not going to make that big of a difference. Like you might as well have, like play hard, work hard. Yeah. Oh yeah, let's talk about that really quickly. So that
You'll be alright.
Do you want to see what I know?
Yes.
It's legitimate, so if you know what I know, but it's legitimate.
Yeah,
So you can all Google fact check me, okay? If you Google it, but basically they had a big special in 2020. 60 minutes. And Allegiant Air, they were saying, has the most number of engine failures. Engine failures, they had just 25 last year alone. And that doesn't include the number of emergency landings they've had to do. And so essentially what they did is in the special, which is all over the internet, they listed how many mechanical issues they've had. Not engine, like the 25 were like the engine just failed in air. The other ones were still the number of mechanical issues on top of that. So essentially they said Allegiant Air is an accident waiting to happen. And so they were saying that the FAA needs to be more strict in terms of you're still allowing them to transport passengers when you see their safety record is piss poor. And so it was so bad that the president of Allegiant Air, because their sales plummeted, because people freaked out like me, because I haven't flown them since, and they said, again, it's on the internet, I'm saying our planes have been inspected and we've addressed our safety issues and blah blah blah. Because their planes, Allegiant Air is really value jet. So when you all were young, and you might have been in the cradle, but when we were younger, value jet was an airline, and they crashed in the Florida Everglades. And so Allegiant Air bought their old planes, so they're really really old, and they just redid the inside, the decor to make it look new, but they're the oldest planes on the market. So, yes.
Who's second? Did they say?
Safety wise? Yeah. No. But so that's why. So if anybody Googled it to see if I'm telling the truth. And you know who told me about it? You can ask her, Professor Jamie Abrams. Because I said, oh, I'm going to Florida and Allegiant, and she like looked horrified. And I was like, what? And so then I went, found the special, looked at it. So yeah, I mean, roll the dice.
If no one doesn't come back.
I didn't know that stuff. Did anybody Google to see if I'm telling the truth?
I just Googled them and it just said there's a 60 Minutes report on it, and their 3.5 times, their safety problems are 3.5 times greater than the other major airlines.
No, you got to see the number of in-air engine failures. That's what got me. The engine like spilling in the air. That's what's me. Okay. So I hope I answered your question. I hope you all have a fabulous spring break.
We'll be here.
See you.
We have office hours for all of them.
She's not coming.
Let's do Caterpillar and do our complaint drafting exercise. We're in rockstar mode. All right. I don't have any volunteers today. So for this case, it's a pretty nice and easy case. Let's just do Attorney Rice. Tanner, are you here? Yep. Tanner's in the house. All right. I love your name. And then, do you want to pick your co-counsel? Wise decision. You would have an enemy for life. What about Attorney Church? Where art thou? Hi. You didn't look that excited. I can't blame him. All right. Either of you mind just giving me the facts and tell me what the citizenship is of the party. So whoever wants to jump in doesn't really matter.
My name is Liz. We're the resident. I've been here all the building. Filed a lawsuit against Caterpillar and Wayne's Supply Company. Caterpillar was from Delaware,
okay,
and Wayne's Supply Company is a Mexican corporation. And then later, Liberty Mutual was about to suit, and they're from Massachusetts.
What was the Massachusetts company?
Liberty Mutual.
All right. Awesome. Thank you so much.
I'm already seeing a problem here.
Pardon?
I'm already seeing a problem.
Okay, we'll hold that thought. All right, so, all right, this is easy. So we've got Plaintiff Lewis, resident of Kentucky, filed a lawsuit in the state court in Kentucky after this bulldozing accident. Not good. Did the case involve a federal question? Attorney Church or Rife? Did I say your name right? Is it Riff or Rife? I did say it right. Okay. Does this involve a federal question, this case? You're shaking your head, but say it. No, and why not? What kind of claim either of you were they alleging?
Negligent meetings.
Excellent. All right, so it's not a federal question case because they were alleging state law claims based on defective manufacture, negligent maintenance, and failure to warn of a breach of warranty. All right, so Attorney Church, who did the plaintiff initially sue? And yes, who did the plaintiff initially sue?
The manufacturer.
Okay, which was? Yeah, Caterpillar Incorporated, and they manufactured the bulldozer. So they're a Delaware corporation. Where's their principal place of business? Alrighty, and then Wayne Supply Company was the servicer of the bulldozer, and as we stated, a Kentucky corporation. So Attorney Church, how did Liberty Mutual get involved in the lawsuit?
The insurance, Lewis's employer's insurance.
All right, excellent. All right, so basically several months later, Liberty Mutual Insurance Group, which is again a Massachusetts corporation, as Attorney Wright said, with the principal place of business in Massachusetts, is the insurance carrier, right, for the plaintiff, Lewis's employer. So they intervened via Rule 24, and I had mentioned to you in the last class they have these joinder rules we'll cover later that allows people that were not originally a party in the suit to intervene or enter the suit if the outcome might impact their well-being. So the insurance carrier for the plaintiff, Lewis's employer, entered the lawsuit as a party via Rule 24 as a plaintiff and asserted a subrogation claim against both Caterpillar as well as Wayne Supply for the workers' compensation benefits that Liberty Mutual had paid to Lewis on behalf of his employer. So subrogation, which is kind of a weird word unless you're in the field of insurance. Basically, it's just circumstances in which an insurance company tries to recoup expenses or a claim it paid out when another party should have been responsible for paying at least part or all of the claim. So there's just, it's like, I remember I had a little minor fender bender when I was in college, and my insurance company paid to have my car fixed, and then they went after the individual that actually hit me to recoup those funds, so that's subrogation. All right, so we know the citizenship of Liberty Mutual was Massachusetts Corporation. So basically at this stage of the lawsuit, we know that there's two plaintiffs since one intervened. Plaintiff Lewis, he's from Kentucky. Plaintiff Liberty Mutual Insurance is from Massachusetts. And again, they're both suing the defendant, Wayne Supply Company from Kentucky, and defendant Caterpillar, that is a Delaware and Illinois corporation. This case is a great example of how multifaceted these cases can get in terms of citizenship, especially when you have corporations, because you know that they potentially are going to have at least two domiciles, which again is a place of incorporation and principal place of business. So what happened next? Who did the plaintiff settle with, Attorney Wright?
The plaintiff settled with Wayne Supply.
All right, and Attorney Church, what type of motion did Caterpillar file?
They wanted the removal of the federal court.
Excellent. All right. So we know that Plaintiff Lewis settled with Wayne Supply Company. Caterpillar then filed a notice of removal from state court to federal court, specifically the Eastern District Court of Kentucky, based on diversity of citizenship. All right. So Wayne. I'll do that. So we know that they settled with Wayne Supply Company. All right. Interesting case. Okay. So what is Caterpillar's argument for removal? Either of you? Why are they saying that they should be able to remove the case from state court to federal court?
Lewis settled with Wayne, so Wayne's no longer part of the suit, so there's diversity.
Yeah, you said it perfect. And you're doing a great job, by the way. So, interesting scenario here. So, as Jessica was kind of alluding to earlier, as long as Wayne Supply Company was in the suit, there was no diversity jurisdiction because there wasn't complete diversity because, again, no plaintiff or defendant can be domiciled in the same state. But once Wayne Supply Company is no longer a party in the suit because they've settled, now we have a situation where there's diversity jurisdiction, and on the face value of things, the case now qualifies for federal question. At least that's what for diversity jurisdiction. So that's what Caterpillar Company at least is arguing. So Caterpillar's argument for removal, as Attorney Wright was saying, is that Caterpillar says, look, we satisfy removal within 1 day to spare the statutory requirement that a diversity-based removal take place within 1 year of the commencement of the lawsuit. And that's a rule that we're not going to be graded on because it's kind of Civ Pro 2, but it's 1446B has that little rule in there. Caterpillar also said that the case was removable because after the lawsuit start, complete diversity was absent because Lewis and Wayne Supply Company were both from Kentucky, and the settlement agreement, as I mentioned, between Lewis and Wayne State would result in dismissal of the action, again, and diversity would be proper. Lewis does not want to move this case to federal court. He intentionally filed the case in state court because he thought it would be more beneficial to his outcome, assuming that he wins. So Lewis says, wait a minute, I have an argument against removing this case to federal court. What does he say, Attorney Church? I mean, yes. What is Lewis's response to the argument he's at the district court level about why removal should not happen?
That Wayne Supply's president of defendants defeated diversity of citizenship.
Yes, because it's not a trick question.
I don't know.
Okay, that's fair. I just wanted to say because Wayne Supply Company was still in the lawsuit and they were from Kentucky. All right, that's why I said it's not a trick question, so I knew the answer. All right, so we know that Lewis acknowledged with Wayne Supply Company, the settlement with Wayne Supply Company, but argued that Liberty Mutual Insurance had not yet settled its subrogation claim against Wayne Supply, and that defeated diversity of citizenship because Wayne Supply was still technically in the lawsuit, and they were from Kentucky. So we know the district court in this case held in favor of Caterpillar. They denied Lewis's motion to remand to state court. So the next question that's important is, why was the district court wrong in that decision? Why were they wrong in allowing the defendants to remove the case to federal court? If you look at the citizenship of the parties on the board, which for those of you I'm blocking in, I apologize, but essentially, although the plaintiff was from Kentucky and settled with the defendant Wayne Supply Company, who is from Kentucky, the plaintiff Liberty Mutual had not yet settled its claim against Wayne Supply Company. So Wayne Supply, which is a Kentucky corporation, was still in the lawsuit. That means there was not complete diversity at the time of removal because plaintiff Lewis is from Kentucky and defendant Wayne is from Kentucky. So I'm going to say that again. So plaintiff Liberty Mutual had not yet settled its claim against Wayne Supply Company, so Wayne Supply Company, a Kentucky corporation, was still technically in the lawsuit. Even though they were in the process of settling, they weren't done. And that means there was not complete diversity at the time of removal. So there has to be complete diversity at the time that you file a motion to remove. And here, that was not the case. So again, because you had a plaintiff and defendant both from the state of Kentucky. So what's interesting is, a question to think about is, eventually, I think the key to really understanding this particular case is that Wayne Supply and Liberty Mutual eventually settled in June of 1993, and Wayne Supply was dismissed from the case by the time the final judgment was rendered in November of 1993. So the defendant Wayne Supply Company, which destroyed diversity, is no longer part of the case. And so that's kind of what screwed everything up. And so Lewis is still upset because the ruling that there was not complete diversity at the time that the removal motion was filed, so they appealed to the Court of Appeals. Plaintiff Lewis's argument on appeal is what? What does he say in the appeal? Take your time finding that. Plaintiff Lewis's argument on appeal. He starts out by saying, all's well that ends well is not a good approach, essentially.
The ultimate satisfaction of certain jurisdiction for not all cases is our court violation.
What you said is correct. I just need you to say it a little bit louder.
The ultimate satisfaction of subject matter jurisdiction requirement ought not to fall into any statutory violation.
Very good. And what does he say, Attorney Church, about what we should do with respect to diversity rules? What does he want? And take your time. It's not a direct question. So what does Lewis make an argument for in terms of how we should use diversity rules? Curiosity is killing me. Keep it free. I'm not upset with you because I know you're prepared. I'm just curious.
I actually didn't read it.
Wow, you've done well. Can we pause and give him some respect? Because that's really impressive guy here. So, is Richard reading today?
I was doing yesterday, but I wasn't reading. I ended up sleeping off.
So, Attorney Church, this is what I appreciate about him. Number one, he did lie, and I really appreciate people that are honest. Number two, I do know those briefs were like a big pain in the neck, so I don't think he's brushing the ass off. So we're gonna move on. Thank you. All right, so essentially Plaintiff Lewis's argument on appeal. As I stated, he said the all's well that ends well is not necessarily a good approach. There was no diversity when the case was moved to federal court because Wayne was still a party, and it doesn't matter if by the time the judgment was ready that Wayne State was no longer a party. Lewis also said that it would discourage plaintiffs, he thinks, holding who timely but unsuccessfully moved to check improper dismissals by the district court. And essentially what he's saying is, look, I want strict adherence to diversity rules. Bottom line, I don't want to have this kind of flexible approach to these types of cases. He said only by removing early, which is improper, was the defendant able to make that 1 year deadline. So he thinks that we just really need to strictly adhere to 1446B, and if they don't make the 1 year deadline, no vote, they do great. So just so you know, once the case gets to federal court, Lewis does lose to Caterpillar. I don't think that's in your abbreviated version. And the only way that Lewis can win now is to say that the federal court had no subject matter jurisdiction, and so the judgment is not binding, and the case should go back to federal court. That's the only option now. So the court does take into consideration the plaintiff Lewis's argument and says, okay, let me think about it. And so the court says that the plaintiff does have valid arguments, okay, which is good, but they run up against an overriding consideration. The court says once a diversity case has been tried in federal court with rules of decision supplied by state law, that they have to consider things such as efficiency and economy, right? They mentioned Erie in your case. We did not cover Erie in Civil Procedure 1, but all Erie says is that there's a trash can there. All Erie says essentially is that if you have a case that qualifies for federal court and you try it in a state court, you have to use a case that can be filed in, how do I make it easier, sorry, because we spent a whole class on Erie, but essentially it means that if you have a case in federal court based on diversity jurisdiction, you apply that state law's rule. Again, Civ Pro 2, not on the bar, but I just want to say, it's basically saying there are certain rules that I'm not going to go over today that tell you when and when you don't have to apply that particular state law's rule. So say I have like here, if we filed a case in Massachusetts, because there's diversity jurisdiction, there are certain rules, legal rules that say you have to apply Massachusetts state law or Kentucky state law, essentially. I'm going to leave it at that. All right, so the court basically says that in the way that removal was set up by Congress, that it ordered a procedure, again, trying to create an expeditious or quick remedy to cases within the district court. That's why they said, again, looking at congressional intent, there's a reason that Congress said, you know what, we're going to give you 30 days for a motion to remand for any defects in the removal procedure. So if anything wasn't done correctly, you have 30 days essentially to challenge it. Additionally, the court talks about, they look at 1447C, again, I'm not going to test you on any of this, and again, just saying that courts generally will not allow you to challenge removals on appeal. They're not reviewable because, again, they have that 30-day window for you to correct any defects that might have occurred in the removal procedure, and again, that's based on 1447C. So bottom line is the court says that to wipe out the adjudication or judgment and return to a state court after the fact is not a good thing. They say it would be an exorbitant cost on our dual court system to do that. So what's important for you to remember for practice purposes is to make sure if you think there are any defects in the removal process that you challenge them within that 30-day window that is specified in 1447C. So they said the unwarranted removal of a defendant will be quickly remanded back to state court per the current rules. And so the ultimate holding in this case is the court held that the district court's error in failing to remand the case and promptly removed it is not fatal at the litigation if the federal jurisdictional requirements are met at the time the judgment is entered. So although the district court was wrong in denying Lewis's motion to remand to state court, meaning to remove the case to state court, because complete diversity was not satisfied when Liberty again and Wayne settled. Wayne's supply was dismissed from the case, and by the time again that the final judgment was rendered in November, there was complete diversity because the only defendant was Caterpillar against Lewis. So this case is kind of convoluted, so I want to really emphasize the takeaway because there are a lot of moving parts in there and a lot of advanced civil procedure practices that you haven't learned yet. So in the Caterpillar case, what's important for you to remember is there was not complete diversity when the case was removed from state court to federal court, and that is an absolute must. So again, in the Caterpillar case, what's important to remember is that there was not complete diversity when the case was moved from state court to federal court. However, the party which destroyed diversity, which again was Wayne Supply Company from Kentucky, was dropped from the lawsuit before the court rendered the final judgment. And the issue again is whether or not the lack of subject matter jurisdiction at the time of removal is fatal, or if it's okay to proceed on. And so the court says that it is okay if at the time of the judgment, right, if at the time of the judgment, the court had proper subject matter jurisdiction. So the court says it's okay if at the time of the judgment, the court had proper subject matter jurisdiction, even if at the time of removal, subject matter jurisdiction was not present. So really what they're focusing on is, did they have proper complete diversity at the time of the judgment? Because a lot of parties can change from when you file your initial complaint until the actual judgment is rendered. And to be honest with you, what happens a lot with the courts trying to deter is people will add defendants that they know that they really shouldn't be in the case and it's probably going to get dismissed. And then like a paralegal, they're going to add the paralegal on as well, purposely to get it in federal court, and then say, oh, when it's dismissed, oh, we still want to keep the case in federal court. It really should have been in state court from the beginning. So that's why there's all these subparts of 1447 to try to deter that you'll learn in Civ Pro 2. But what's important again for you to remember is to look at whether there's complete diversity at the time the final judgment is rendered. And to remember that if there's any defects in removal, you have 30 days to challenge it from that original motion that's made to saying we want to remove the case from state court to federal court. Once that party files that motion, you have 30 days to say no, removal isn't proper because there's diversity. there's not diversity jurisdiction or complete diversity. So any challenge, you have 30 days from when the initial motion is filed. So for exam purposes, what I care about you knowing for just civil procedure 1 is that removal, again, is from state court to federal court. It's something that the defendant uses. It's a tool that's used by the defendant, not the plaintiff, because remember, the plaintiff filed where they wanted their case. All right? And that you have to have complete diversity when you're removing the case from state court to federal court. That's what you need to know, for example, the extent of removal. All right.
Sometimes it won't let me back. Should I give her the signing sheet? I'm asleep. I think I passed it. I'm sleeping. That's what, isn't it? I don't even remember doing it.
Where's his
Technically, no. There's no telling where I put it.
You like the attendance sheet? Okay, it's fine. Oh, some people
I
did.
did pass it. It wasn't me. I need to go to bed. We gotta get that today. I'm done. Thursday.
On Thursday?
Yes, like,
Why can't it act like you could? You know what I'm saying? He kept calling out like I can't change it. Do you have one?
no.
Walker looks like a disheveled teenager with
He
gray
acts
hair.
like one.
With gray hair. Like whenever I see him, I'll be like, what's this Walker? What's a
He acts
teenager with
like
gray
one.
hair?
He's very like, all over the place. But he teaches very well. But to get started, I'm gonna buy you a backpack. You get a backpack.
On a side note, so I do have human moments. If I've already called on you this semester, just say something. Say, yo, you've already called on me. I already called on for Attorney Church, so there's no reason for the thing. Yeah, just say something. Say, yo, it's okay. Just say you already called on me. Leave me alone. It's really cool. So I'm sorry that happened. He still did a great job.
I would fill out my shirt. Make it hard to cut.
A wig.
I'll be practicing at home. I do. You never know when I have to pull it out of that. And then my wig came out. I was ready. I was waiting for somebody to say, please remove your hat. Okay.
Are you kidding me? Yes, and I'm done. I'm signing in.
I don't feel like reading it. I don't like another thing.
I'm not reading it.
Why are you killing my heart? I'm sick. I got a disability. They really do need to make it a disability. Some days I really don't. PCOS. Why does it take 2 hours?
Because I'm already notorious for being there during guest speeches. A lot. I'm telling this like 3. What do you mean a lot? I think the only things I've ever done to
All right,
get
so, oh, one more up there. All right.
Okay, hopefully. Don't touch yourself.
I'm about to start singing hymns. I'm going to do this.
Okay, so here's how this works. I have given you, okay, so this, you obviously have the directions. The sample is just helping you fill out the blank sheet, kind of showing you what goes into a complaint. So the first section, you're going to tell the nature of the action. So you should have, oh no, did they not print the facts? Oh no, Kia. Kia didn't give you the facts. What's Kia doing? Oh, Kia, you messed up my whole exercise. Tell me where the facts. That's why you guys are looking at me crazy. So let's take a 5-minute break, and I'm going to go see if Kia has my facts upstairs. Yep, don't do that. 5 minutes. Kia has my facts. I'm sorry. She has enough to cover.
She was just
Hey, get up and move. Start feeling weird.
I'm dead. Move what? She was in here fixing the club earlier. And no professor else in my finger just to see what's happening. Do you know anything you think I believe I could lie anymore? You ruined our lives.
Oh. I've dirty complaints.
They think the world's greatest.
You complain every day. You wake up complaining shit, having anxiety attacks on the spot. That's what annoys the anxiety attacks. On the spot. No, Chloe.
Because I check that thing on Thursday.
That's a lie. That's at most 11.
I don't like feet. I didn't realize I was 14.
I don't even know what to do in I can't even get my mind right. I'm going to do the What do we just I don't want to lawyer today. I can't lawyer today. Good. We almost lost you.
All right, now we're ready. Go.
I'm not.
You have the relevant facts. You have a sample, what you should include. That's hiding from me. But you have a sample, voila, and a blank one. So you're going to pull the facts you need out of your relevant facts, just like an attorney's going to give you a file. This is what's going on. I need you to draft a complaint. Associate Hart, Associate Gross, Associate. I know, remember the names. And that's it. And then we'll see what you have. So you got this. But you see why you needed to know jurisdiction and venue and the parties? It's all making sense. You need civil procedure. Just draft. This is what you would file in court when you start your process. It's exciting. You can go file a case right now. Pro se. You can rip apart all you need to. Yes, sir.
So we just knew that you would sue the mutual, because I don't remember saying it in the case.
No, it's in the what do you call it? That's an abbreviated version. I was giving stuff from the full version of the case. You're welcome. All right, so you want me to play Jeopardy music, or you guys should, sometimes the silence is awkward for me.
Speaking of the categories, I don't remember Big Worm being a part two.
Big Worm?
She changed categories.
Thank you. I need to know who actually did it. So that's helpful. You know? So I'll be honest, when they said I had her section, I was a little concerned. I actually really like her section.
What do we do? What does that mean?
I only have our
We have a good
I just
section.
heard something, but I'm really enjoying your section.
They said we're the mean section.
And with that being said, I really need you all to like, I need this to be like legendary. I need like the most A's ever in civil procedure. Like you seem like you understand it. We're gonna have a rock star section, review session. After spring break, I'm gonna go hardcore. So I'll be doing like civil procedure questions of the week, questions of the day, like constantly asking me stuff that we've already covered. But I need you to make history ecological this session. And this is the first time I feel like you can do it. Like people actually understand it pretty well. So please, I need like 90% A's, rock star. I need to write up on the website. So it's not just about you, it makes me look really good. So I need you to do really well. But go ahead and do your complaint drafting exercise. And oh yes, sir. That's a really good point. So I need to make an extremely generous curve, and I support that.
Or easy questions.
No.
Not easy.
That's the bar. It would be regular bar questions. Elizabeth.
Are we turning this in?
This is what I need you to understand. Now, you're supposed to be like supporting each other, colleagues. So when you see your colleague go rogue, why did nobody stop
I
her?
didn't even see
I
that.
did.
This whole road was on her.
I was like talking to the people in the
Going rogue. That was me, actually. I was like, no, she encouraged me. She was on my lookout. Like,
See, so now you cannot do anything. You should have said that she looked out. You're supposed to be fine.
I just don't. I don't see them do anything. I don't pay attention to them.
You tune out.
she's the voice
They
of
always
reason.
doing something.
She tells me to be quiet.
She ignores all.
She's an innocent bystander. She used to be over there, and this used to be our row, and then, she came.
She couldn't see me, and we done.
Like, there are but I think, well, no, I have contacts, but like, I think it's just all the readings I am future.
No, it's true. Okay, I'm gonna let you guys do
Yeah, I keep turning around. She's.
Yeah, she tells me to shut up.
She let her do that.
I swear, I was like back there.
I'm already with the company.
She's an
I'm
adult.
awesome. You should stop
Just
telling me.
get yourself together, bro.
It's not
Oh my God, it's like a little headband. I can't wait.
I don't even know what to do.
Can y'all take me to the chapter?
And again, in prayer for relief, it's just how much money you're asking for. And damages.
I can do civil action one day.
That one cross this.
Just as a side note, hopefully no one else did this, but you do know that this is just the first one, it's just a sample, a model, and then you're creating your own brand new complaint. Okay, just making sure. decided to up the ante. I'm feeling excited about spring break. I wasn't going to collect them, but I'm going to collect them at exactly 10:15. And whoever has the two, I'm going to pick the two best out of the class, and I'm going to bring you, what, Starbucks gift cards? Starbucks good? Where? What's good? Chick-fil-A gift cards.
What?
Dimitri, don't distract us.
It was chicken fillet.
So I'm going to collect them. I'm going to pick the two top ones. I'm going to show them on the overhead, and I'm going to bring gift cards.
You know, you said punch you too.
You know the front row is not going to be eligible because they've been moving off the whole time. Of course.
I'm sweet.
Bitch, y'all, we don't want you talking about goofy.
I'm not worried about it. I'm sweet. Is this for great? No, exactly. You know what? I'm fed up. You probably say that too.
Wait a second. I think I'm doing it wrong.
You probably are. I know that.
I think I'm doing it on the wrong side. She has a clue.
And in terms of the statement of the claim, that's just what claim, a brief statement. An example would be plaintiff seeks redress or recovery for a discrimination claim based on Title VII, and that's it. So whatever type of claim, or negligence claim. I don't want to know. So it's just a brief statement of what they're claiming the wrong is, what legal harm has been done. You've gone from like super massive potential to you can be either side of this.
Oh, okay.
You're supposed to be represented.
Okay, so this is part of something.
Yeah. Okay. You're gonna get the picture? You're gonna finish it. You're gonna finish it. That's actually cool. She had his own water, I see that. people, well not a lot, two people asked about the district. It's in Corpus Christi, Texas. So if you just Google it, it'll tell you what district it is. Corpus Christi in the back. And that's what you have to do with a real client as well. If there's not a state, you're trying to see if there's ever a jurisdiction. Yeah, so it's nice enough to share Southern District of Texas. We're almost done. Statement of the claim. What is he saying? He's claiming what wrong has been done. Is Faustine gonna come today? Do I get to see her?
She usually comes in.
This is too much paper.
So you make me look bad. You know I was gonna bring the donuts on Monday, but it's too cold. Because your English has to be
You say thank you, you got no yet.
No, that's see, that's not.
Oh, I know, I don't know what it is. This should be Southern District of Texas.
I ain't finished. This is a hot mess. I ain't winning.
Oh, I thought you could.
Yeah, thank you. I'm trying not to make it up.
I ain't finished, but I tried.
That's what you had distractions over here. None of that's your fault.
Thank you.
Oh, sorry, I was trying to get it.
I wonder if we have it.
Thank you. Ma'am, you can go I am leaving. Oh my
All right, what do you rock? That's fine. You'll give you a headache before the day's over. Please give a headache.
Excellent. So yeah, you gotta go. Okay, James. There you go.
So then,
Those are still carries on work. No, usually she brings it this way. No, we have a lot of elbow room. It goes this way. See, you're confused too. Usually it has this way. I want like 8 more donuts. I want a baby. This needs to start.
King K just
My unit is shaking. And then got haircut. This might happen.
John. Why are you here? She's so rude. This is class.
You have to stay in this like Who's on call today?
Not me. But I did read though.
Yeah, I'm not on call either.
You need to get up and exercise. Are you still right here?
Who's on call today? All right.
What's your name, Patrick? Your last name?
Okay, happy Mardi Gras. How many of you know what Mardi Gras is?
So you go to
It's a bad thing. It means Fat Tuesday, but it's beginning tomorrow's actually the beginning of Lent, and French, New Orleans is French. And Houston has a lot of pagan influence, so we're very rare.